Assalamualaikum warahmatullahi wabarakatuh. My name is Nurziyanah Binti Zainul. My mention number is 1250981, and in this video, I will be presenting a case review of Sulaiman bin Takrib versus Kerajaan Negeri Terengganu. This is a constitutional case which involves Islamic law and the Federal Constitution of Malaysia, particularly concerning the division of legislative powers between the federal and state governments. So firstly, I will be explaining about the parties involved in this case. This case involves two main parties. The first one is known as Sulaiman bin Takrib. He is the applicant who was charged under the Sharia Criminal Offences Taksir Terengganu Enactment 2001. And the respondent is the Kerajaan Negeri Terengganu, representing the state authority that enacted and enforced the Sharia criminal law in question. So this dispute arose when the applicant challenged the validity of the state law, claiming that it exceeded the legislative powers granted under the Federal Constitution. So next, I will be explaining the facts of the case. So the petitioner Sulaiman bin Takrib, he is a Muslim and he was arrested under two occasions in July 2005. He was charged in the Sharia Subordinate Court Act Taksir Terengganu with offences under Section 10 and also Section 14 under the Sharia Criminal Offence Taksir Terengganu Enactments 2001. So Section 10 of the enactment deals with acts that are contrary to Hukum Syara, including conduct that goes against Islamic teachings as determined by the religious authorities. Meanwhile, Section 14 on the other hand, it relates to matters involving publications, documents or materials that are basically considered to be against Islamic law or that promote teachings contrary to Islam. So, in this case, the applicant was alleged to have been involved in activities and possession of materials that were deemed to be inconsistent with Islamic teachings as determined by the relevant religious authorities in Terengganu. So, his actions were said to be in contravention of a fatwa that had been issued and gazetted by the State Fatwa Committee. So next, Sulaiman, he was accused of defying a fatwa that had been issued and published in the Government Gazette of Terengganu in the 4th of December 1997. This fatwa declared that the teachings of Ayah Bin, also known as Arifin Muhammad, were false, deviant and misleading towards the Aqidah of Muslims in the state. The fatwa also prohibited all Muslims in the state to be associated with the teachings of Ayah Bin. So on the 2nd of July 2005, Sulaiman was arrested for being involved with Ayah Bin. Later, on the 23rd of August, he was charged under Section 10 of SCOI for disobeying a fatwa and under Section 14 of the same enactment for possessing a BCDA containing materials that are contrary to Hukum Syara. While the trials in the Sharia courts were pending, Sulaiman filed a constitutional petition in the federal court seeking a declaration that the following provisions were null and void because the State Legislative Assembly of Terengganu had exceeded its legislative powers in enacting those provisions. He also argued that the offences under Section 10 and 14 were offences against the precepts of Islam as required by Item 1, List 2 in the 9th Schedule of the Federal Constitution. He contended that the phrase precepts of Islam should only refer to the 5 pillars of Islam, which is faith, zakat, prayer, fasting and pilgrimage, and not to matters such as fatwa disobedience or possession of Islamic materials. According to the applicant, the offence in question related more to criminal law which falls under the federal list, and therefore only Parliament had the authority to legislate on such matter. So next, I will be explaining the legal issue in this case. The legal issue in this case is whether the offences created under the Sharia Criminal Offences Taksir Terengganu Enactment 2001 fall within the state's legislative power over Islamic law under the state list, or whether they amount to criminal law, which is a matter exclusively reserved for the federal legislature under the federal list of the 9th Schedule to the Federal Constitution. So, the legal issue in this case concerns the constitutional division of legislative powers between the federal government and the state government. So, under Article 74 of the Federal Constitution and the 9th Schedule, the power to make laws is divided into matters under the federal list and matters under the state list. So, criminal law is placed under the federal list, meaning only Parliament has the authority to enact criminal offences. On the other hand, states, they are allowed to make laws relating to Islam, but this power is limited to matters specifically provided under the state list. In this case, the Terengganu State Legislative Assembly enacted provisions under the Sharia Criminal Offences which created offences and imposed punishments for acts such as acting contrary to fatwa and possessing prohibited materials. The legal issue arose when the applicant challenges these provisions, arguing that although they were labelled as Sharia offences, their substances and effect were that of criminal law, which falls under federal jurisdiction. Therefore, the court had to determine whether the impugned provisions were valid state laws on Islamic matters or whether they were in fact criminal law, in which in this case the Terengganu State Legislature would have acted ultra vires the federal constitution. So next, I will be explaining the court's decision and the reasoning. So the decision of the court is the federal court dismissed Sulaiman's petition, holding that the State Legislative Assembly did have the power to create offences for disobedience of fatwas, making those rulings legally binding. So the court reasoning is, firstly, the court determined that the impugned sections of the Terengganu Enactments Court fell within the state power. It held that while criminal law is primarily a federal matter, state still have the power to create offences in respect of matters included in the state list. So, the judges reasoned that the challenged offences were concerned with the precepts of the religion of Islam, which falls under the state list. Secondly, the court adopted a broad interpretation of the phrase of precepts of Islam. The judges determined that the term was not limited merely to the 5 pillars of Islam, which is faith, prayer, fasting, charity, and pilgrimage. The wide scope allowed the court to conclude that offences related to deviant teachings such as ayah-bin or the possession of material contrary to hukum syara are indeed against the precepts of Islam. Lastly, the judges reasoned that the fatwa itself is a religious ruling, a function within the state's power to determine Islamic law. The actual creation and the prescription of punishment for disobeying the fatwa was done by the state legislative assembly. So this maintained the constitutional separation. Guys, I will be explaining the principle of law applied in this case. So, the first one is, the federal constitution is the supreme law of the land and any law inconsistent with it is void. So, in this case, the federal court reaffirmed the doctrine of constitutional supremacy. So, this means that all laws, including Islamic law enacted by the state legislature, must comply with the federal constitution. So, if a state law goes beyond the powers granted by the constitution, it is unconstitutional and void. The second principle of law is legislative powers in Malaysia are divided between the Federation and the state, according to Article 74 and the 9th Schedule of the Federal Constitution. So in this case, the court applied Article 74 and the 9th Schedule of the Federal Constitution to determine whether the state of Terengganu had the authority to enact the offences. So matters relating to criminal law fall under the federal list, while state may legislate on Islamic law only within the limits of the state list. The third principle of law is the federal court held that the power of states to legislate on Islamic law is not unlimited. Islamic criminal offences created by the states must fall strictly within the scope of offences by persons professing the religion of Islam against the precepts of that religion as stated in the state list. So any offences that resembles general criminal law exceed state's power. Last but not least, a fatwa issued by a state fatwa committee becomes legally binding once it is gazetted, and it may be enforced through state legislation. So in this case, the federal court recognized fatwa as an integral component of Islamic law, not merely an advisory opinion once it is gazetted. So next, I'm going to explain what I understand about this case. So from my perspective, this case illustrates how religious legislation in Malaysia remain subject to constitutional limits. Although states are empowered to regulate Islamic law, that power operates within the framework of the Federal Constitution. Based on Article 11, subsection 4 of the Federal Constitution, it allows states to manage Islamic teaching, which includes the enforcement of fatwas and action against deviant doctrines. So this decision is important because it shows that Islamic precepts are interpreted broadly, and it confirms that fatwas have legal consequences, and it also affirms that the state's role in governing Islamic affairs among Muslims. So to conclude, the case of Sulaiman bin Takrib versus Kerajaan Negeri Terengganu clearly demonstrates how the federal court interprets the constitutional division of legislative powers between the federation and the states in matters relating to Islamic law. The court also affirmed that the state legislatures do have the authority to legislate on Islamic law, including the creating of offences against the precepts of Islam. However, such authority is not absolute. The court emphasized that these laws must apply only to persons professing the religion of Islam and must remain within the jurisdiction of the Sharia courts as provided under the federal constitution. This decision reinforces the principle that while Islamic law is recognized within the Malaysian legal system, it must always operate within the constitutional framework and be subject to judicial review by the civil courts. So I guess that's all from me. Thank you.